In the old days, the cops would just let him keep the money.
Ladies and gentlemen, the story you are about to see is true.
Civil asset forfeiture. Sounds pretty crazy, doesn't it?
The money comes in, it's first given to the county treasurer, and it's held in escrow until we get a resolution of the case. And once the matter is resolved, if the money is forfeited, if the money was taken by the county prosecutors, detectives themselves, it goes to our office. If it's taken by a local municipal police department, they get a bulk share. Usually 75 to 85% of the money will be distributed on a biannual share to the local municipal police departments.
So there's an incentive then for local police to be trying to forfeit cash assets of criminal activity?
Well, there is an incentive, yes. I mean, civil asset forfeiture is a pretty important component of the criminal practice, and the money that goes to the local police departments does provide some assistance to them. Typically what we get are automobiles,
right.
Flat screen TVs, computers, cameras. We don't get a lot of jewelry and things like that because they're very difficult to dispose of. But discussing vehicles, we take a vehicle in. If the vehicle is in good condition and the police want to put it on the road as an undercover car or paint it up as a dare vehicle, right, and we forfeit it, we will give it to the local police department. If they don't want it, for whatever reason, the vehicle is not in good condition, and it's just not roadworthy, they tell us to auction it. We will put it up for the annual auction. Whatever money we get in is almost like cash being brought in for forfeiture. It's distributed to the local police department. The bulk of the vehicles that we take in are registered to someone other than the defendant.
Right.
Okay? And when we get that situation, what we have to do is, first of all, evaluate the facts of the case. We read the police reports. And most importantly, what I do is I actually take a physical look at the car. Because what we're concerned about mostly is who is using the car more than not. I know that the car is registered in the name of the grandmother or the aunt or someone like that, but really it's the defendant who's using the car on a day-in and day-out basis. The defendant's clothes, the defendant's papers, the defendant's other personal belongings are in the vehicle, and we can demonstrate by the contents of the car that the defendant is really almost exclusively using that vehicle, in which case the court then would declare that person the beneficial owner, and the innocent owner doesn't have the defense. When the cops get tired of the same calls coming from the same residents week after week, if the individual is going there in his car and he knows he's violating the restraining order, take the car. Hey, we like that car. We're going to take it.
You know, I used to see some of the bosses in your office riding around in some pretty nice cars, and I used to think to myself, gee, I wonder if these were cars that were subject to forfeiture by big drug kingpins, and after the forfeiture, the prosecutor's office kept them as vehicles and made them available as Percocets for some of the upper echelon prosecutors. Does that happen?
We have used forfeited vehicles to give to not only detectives, but assistant prosecutors. I know that the head of SIU drives a forfeited vehicle typically. Because we're not in criminal, we are in civil with forfeiture, we have to allege an indictable offense. The matter, for whatever reason, can be downgraded. In fact, our office can dismiss the charge altogether because we don't feel there's enough evidence to prove it beyond a reasonable doubt. We are in civil when it comes to forfeiture. The standard of proof is preponderance of the evidence. As you know, a significantly lower standard of proof. So even though we may not have enough evidence to prove a criminal action beyond a reasonable doubt, if I determine that we have enough evidence to prove a criminal indictable offense by a preponderance of the evidence, we can still go forward in civil forfeiture. So many times, a significant portion, I'd say maybe 30–40% of my forfeiture actions involve charges that are eventually downgraded, but we still proceed forward on it because there's enough evidence to demonstrate by a preponderance of the evidence that the indictable offense occurred. And in fact, we don't even have to have a charge initially for an indictable offense. We don't have to charge anyone at all. We had an individual who had a nice brand new Infiniti G35. He got a workers' comp settlement, spent all $65,000 buying a top-of-the-line Infiniti G35, fully loaded, and 3 weeks later, he gets in a fight with his girlfriend. He reaches out the open driver's side window, grabs her, hits the gas, drags her down the street 100 feet and injures her. We took the car, and we got it in forfeiture because it was used to commit a third-degree aggravated assault. You know, again, a lot of sex crimes, individuals even involved in statutory rape cases. If they're committing the statutory rape in the backseat of the car becomes subject to forfeiture. Money laundering is a tool. I know the feds charge money laundering in almost every case, but it's not often used in the New Jersey courts. But money laundering is a good basis to take a car, especially when you think it was purchased with the proceeds of drug money. It's a very effective law. We're not really looking for a lot of computers. Everybody's got one already. But sometimes we do file for them simply because we just don't want the guy getting it back.
Theoretically, if the Trenton police, for example, wanted to set up a sting where they put an undercover officer out on the street and people were driving up as Johns, and she said, all right, meet me around the corner, and the police arrest them, that vehicle could be subject to forfeiture.
It is subject, and we have done those cases. We have had sting cases in the past where we've taken vehicles.
Notwithstanding the fact that it's a disorderly person offense.
Yes, we've done it in the past. What we're talking about here are cash or assets that can be utilized by law enforcement. Motor vehicles, computers, flat screens. We're not interested in taking a charter from a company as forfeited asset because it doesn't have any monetary value to law enforcement. We can take homes. We've done it in the past. I know that the feds are very big about seizing property. The Criminal Justice Division of the Attorney Generals have taken homes. I think they still have them. They haven't been able to sell them. What we prefer to do is we can file a noticeless pendants against the property. We can file for forfeiture of the property, but what we prefer to do is negotiate something that tells the defendant, if you agree to sell the property, you do the soil test, you do the radon test, you do the home inspection, and you get the real estate agent and get all that done, we will split the equity, what's ever left over, we will split that with you. Cell phones, you know, are seized often. We really don't file for forfeiture of cell phones. There are so many of them out there. Everybody's got one. We really don't have a need for it, but we could if we wanted. Motor vehicles, as I said, you know, that's a big component in all aspects of criminal prosecution, from drug cases to DV to homicide, robbery, theft, assault, whatever. Vehicles are always involved. And homes and other property. Other property includes anything from flat screen TVs to furniture to fur coats. The flat screens are very popular with the police departments. They need them for training rooms. They need them for their 911 dispatch centers. I know that we've been, as we get them in, we call the police departments, do you need one? Yes, we do. And, you know, where do you need it? Well, you know, we need one for our training room. We need one to monitor our surveillance camera in our lockup cell. So we've been giving the flat screens out to the police departments as on a needed basis. And every flat screen so far that we've taken has been put to use in a police headquarters or in a training room. Proceeds of criminal activity, primarily money. Just like Eugene Krabs, everybody likes money. Money's easy to distribute to the police departments. It's easy to file for. The money comes in. It's taken to the county treasurer. It's put into essentially an escrow account. We file for it. And however it's resolved, whether we do a split of the money or we get it all, it then goes to our it comes to the forfeiture account, and it's distributed from there to the local police departments or to our office. We get the cash from the sale at the auction, and that's, again, turns into cash.
Okay.
So, but we're talking proceeds. We do seize jewelry in some cases, typically in drug raids. There's a lot of jewelry in the house. We can take that. Watches, earrings, necklaces, things like that, things that were obviously purchased with the proceeds of drug money. We have had some large seizures on the turnpike where there's no drugs in the car, but we believe the money was being taken up to New York to purchase drugs.
Right.
Okay. So they will take the money and they will do the sniff test with the dog, where they take the money somewhere in police headquarters, they put it in a bag, they stick it in a locker, they bring the dog in, the dog walks around the room, the dog hits on that locker.
Right.
And the dog alerts that there's at least a scent of narcotics on the money. A lot of times they do a street-level investigation, do a stop and do a Terry stop, okay? They suspect the person's engaged in narcotic activity or some other criminal activity. They stop and do a Terry search, okay? They pat down. They don't find any drugs or any weapons, but they find a huge bulge in the pocket. What's that? That's money. Yeah? How much? I don't know. So the cops take it out and count it. If there's a significant amount of money in a drug dealer's pocket but no drugs, I still encourage them to seize it because we can charge money laundering. In years past, leases and rentals were automatically returned to the rental agency or to the leasing company. Okay, they take a car, they find it's an Enterprise rent-a-car, they call Enterprise, and Enterprise comes and picks it up from the station house. I recommend not to do that for all kinds of reasons. Okay, I believe that if the car is taken, just like it is on a lien situation, turn the car over to us, okay, because it is subject to forfeiture, okay? And there may be reasons why we want to forfeit the car. We're not out to supplement our budget. We're not out to get ourselves some early Christmas presents. That's not what it's about. But once we do get title, and we get title to a lot of this stuff, I mean, we do succeed in the bulk of what we file for. So it's there, and we're patient, we'll wait, and we'll do it the right way.